So this is Circuit Judge Lee writing. In the wake of heart-wrenching and highly publicized mass shootings, the state of California barred its citizens from owning so-called large-capacity magazines that hold more than 10 rounds of ammunition. But even well-intentioned laws must pass constitutional muster. California's near-categorical ban of large-capacity magazines strikes at the core of the Second Amendment, the right to an armed self-defense. Armed self-defense is a fundamental right rooted in tradition and the text of the Second Amendment. Indeed, from pre-colonial times to today's post-modern era, the right to defend hearth and home has remained paramount. California's law imposes a substantial burden on this right to self-defense. The ban makes it criminal for Californians to own magazines that come standard in Glocks, Berettas, and other handguns that are staples of self-defense. Its scope is so sweeping that half of all magazines in America are now unlawful to own in California. Even law-abiding citizens, regardless of their training and track record, must alter or turn over to the state any LCMs that they may have legally owned for years or face up to a year in jail. The state of California has latitude in enacting laws to curb the scourge of gun violence and has done so by imposing waiting periods and many other limitations. But the Second Amendment limits the state's ability to second-guess a citizen's choice of arms if it imposes a substantial burden on her right to self-defense. Many Californians may find solace in the security of a handgun equipped with a large-capacity magazine. Those who live in rural areas where the local sheriff may be miles away, law-abiding citizens trapped in high-crime areas, communities that distrust or depend less on law enforcement, and many more who rely on their firearms to protect themselves and their families. California's almost blanket ban on LCMs goes too far in substantially burdening the people's right to self-defense. We affirm the district court's summary judgment and hold that California Penal Code Section 32310, the ban on LCMs, runs afoul of the Second Amendment. Millions of Americans across the country own LCMs. One estimate based in part on government data shows that from 1990 to 2015, civilians possessed about 115 million LCMs out of a total of 230 million magazines in circulation. Put another way, half of all magazines in America hold more than 10 rounds. Today, LCMs may be lawfully possessed in 41 states and under federal law. Notably, LCMs are commonly used in many handguns, which the Supreme Court has recognized as the quintessential self-defense weapon. For example, several variants of the Glock pistol, dubbed America's gun due to its popularity, come standard with a 17-round magazine. Almost all Glock models, except for subcompact variants designed for concealed carry, come standard with magazine capacities greater than 10 rounds. Another popular handgun used for self-defense is the Beretta 92, which entered the market in 1976 and comes standard with a 16-round magazine. Indeed, many popular handguns commonly used for self-defense are typically sold with LCMs. Virginia Duncan and other plaintiffs who lawfully acquired LCMs or represent those who do, collectively we're calling them the owners, brought a constitutional challenge to California Penal Code 32310. 2 days before the possession ban was to take effect, the district court issued a preliminary injunction enjoining enforcement of the law. On appeal, this court affirmed. The Second Amendment provides, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In 2008, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms in the Heller case. The court later incorporated the Second Amendment to the states through the 14th Amendment's Due Process Clause in McDonald v. City of Chicago. A citizen's right to self-defense, the court held, is deeply rooted in this nation's history and tradition, and fundamental to our scheme of ordered liberty. And indeed, history, text, and tradition underscore that the right to an armed self-defense is fundamental. As the McDonald decision noted, many legal systems from ancient times to the present day have recognized the right to defend oneself from aggressors. From 1639 to 1660, the British people endured a civil war, and the creation and dissolution of a republic during the interregnum until the Stuart monarchy restoration. Starting in 1662, the Catholic Stuarts persecuted their political enemies, enacting laws that dispossessed all arms from those deemed dangerous to the peace of the kingdom. In 1670, Charles II further restricted possession of guns to the exclusive benefit of the wealthy, the purpose being the prevention of popular insurrections and resistance to the government by disarming the bulk of the people. In the continuing tumult of the Protestant Reformation, James II and VII continued these policies by trying to disarm Protestants while allowing Catholics to maintain arms. Such despotism led to the king's ouster through the Glorious Revolution of 1688 and the enactment of the Declaration of Rights in 1689. Among these true, ancient, and indubitable rights was the right of Protestants to have arms for their defense suitable for their condition, as are allowed by law. And in April of 1775, and closer to home, a ragtag group of private citizens armed only with their personal firearms and makeshift weapons fired the shot heard round the world in Concord, Massachusetts. Reminders of British efforts to confiscate personal firearms filled the founders' minds when drafting the Bill of Rights in 1789. During the ratification of the Constitution, anti-federalists raised alarm over a potentially despotic national government that could disarm the people, as occurred under the Stuart kings and other British regimes. In response, the Federalists agreed to include a Bill of Rights, which of course featured the right to bear arms. In sum, self-defense is a basic right recognized by many legal systems from ancient times to the present day, and individual self-defense is the central component of the Second Amendment right. Heller's holding ultimately led the court to invalidate a District of Columbia law that virtually banned all handgun possession in the home and further required all other firearms to be unloaded and disassembled or bound by a trigger lock or similar device. The court found the inherent right to self-defense to be a critical component of the Second Amendment, and that the virtual handgun ban was constitutionally infirm because the handgun is the quintessential self-defense weapon. The court similarly found the disassembly or trigger lock requirements unconstitutional because it makes it impossible for citizens to use arms for the core, lawful purpose of self-defense. But the ruling in Heller was not unlimited and rejected the idea that citizens may keep and carry any weapon whatsoever, in any manner whatsoever, or for whatever purpose. Heller thus recognized that certain exceptions to the Second Amendment apply. For example, weapons that are dangerous and unusual fall outside the Second Amendment's protection. Furthermore, the court cited an open-ended list of presumptively lawful regulatory measures that constitute acceptable long-standing prohibitions on firearm ownership. Such prohibitions include possession of firearms by felons and the mentally ill, prohibitions on carriage in sensitive locations, and conditions or qualifications on the commercial sale of firearms. Firearm magazines are arms under the Second Amendment. Magazines enjoy Second Amendment protection for a simple reason. Without a magazine, many weapons would be useless, including quintessential self-defense weapons like the handgun. We have opined that where firearms are commonly possessed by law-abiding citizens and for lawful purposes, then there must be some corollary, albeit not unfettered, right to possess the magazines necessary to render those firearms operable. In Jackson, we held that ammunition is a protected arm because, without bullets, the right to bear arms would be meaningless. The Second Amendment guarantees the right to carry weapons typically possessed by law-abiding citizens for lawful purposes. A weapon may not be banned unless it is both dangerous and unusual. In addressing unusualness, the Supreme Court held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. In other words, just because a weapon was not in existence during the founding era does not mean it is unusual. And where a weapon belongs to a class of arms commonly used for lawful purposes, the relative dangerousness of a weapon is irrelevant. That LCMs are commonly used today for lawful purposes ends the inquiry into unusualness, but the record before us goes beyond what is necessary under Heller. Firearms or magazines holding more than 10 rounds have been in existence and owned by American citizens for centuries. Firearms with greater than 10-round capacities even existed before our nation's founding, and the common use of LCMs for self-defense is apparent in our shared national history. Semi-automatic and multi-shot firearms were not novel or unforeseen inventions to the founders, as the first firearm that could fire more than 10 rounds without reloading was invented around 1580. Rapid-fire guns, like the famous Puckle gun, were patented as early as 1718 in London. Moreover, British soldiers were issued magazine-fed repeaters as early as 1658. As a predecessor to modern revolvers, the pepperbox pistol design predates the American Revolution by nearly 100 years, with common variants carrying 5 to 7 shots at the ready, and with several European variants able to shoot 18 or 24 shots before reloading individual cylinders. Similarly, breech-loading repeating rifles were conceptualized as early as 1791. After the American Revolution, the record shows that new firearm designs proliferated throughout the states and few restrictions were enacted on firing capacities. The Girandoni air rifle, developed in 1779, had a 22-round capacity and was famously carried on the Lewis and Clark expedition. In 1821, the Jennings multi-shot flintlock rifle could fire 12 shots without reloading. Around the late antebellum period, one variant of the Belgian Mariette repeating pepperbox could fire 18 shots without reloading. Pepperbox pistols maintained popularity over smaller capacity revolvers for decades, despite the latter being of newer vintage. At this time, revolving rifles were also developed, like the Hall rifle that held 15 shots. The advent of repeating cartridge-fed firearms occurred at the earliest, in 1855 with the Volcanic Arms lever-action rifle that contained a 30-round tubular magazine, and at the latest in 1867 when Winchester created its Model 66, which was a full-size lever-action rifle capable of carrying 17 rounds. The carbine variant was able to hold 12 rounds. Repeating rifles could fire 18 rounds in half as many seconds, and over 170,000 were sold domestically. The Model 66 Winchester was succeeded by the Model 73 and Model 92, combined selling over 1.7 million total copies between 1873 and 1941. You wouldn't download a gun. The innovation of the self-contained cartridge, along with stronger steel alloys, also fostered development in handguns, making them smaller and increasing their capacities. Various revolver designs from France and Germany enabled up to 20 shots to be fired without reloading. A chain-fed variant, the French Goicot, allowed pistols to carry up to 32 shots and a rifle up to 100 shots. One American manufacturer experimented with a horizontally sliding row of chambers, an early stacked magazine, through a common frame, dubbed the Jarrah Harmonica pistol, holding 10 rounds and patented in 1862. In 1896, Mauser developed what might be the first semi-automatic recoil-operated pistol, the broom handle, with a detachable 20-round magazine. Luger's semi-automatic pistol hit the market in 1899 and came with 7 or 8 round magazines, although a 32-round drum magazine was widely available. In 1935, Browning developed a 13-round high-power pistol, which quickly achieved mass-market success. Since then, new semi-automatic pistol designs have replaced the revolver as the common, quintessential self-defense weapon. Many of these pistol models have increased magazine capacities as a result of double-stacked magazines. One of the most popular handguns in America today is the Glock 17, which comes standard, with a magazine able to hold 17 bullets. Rifle magazine development paralleled that of pistol magazines. In 1927, Auto Ordnance Company released its semi-automatic rifle with a 30-round magazine. A decade and a half later, the M1 carbine was invented for the citizen soldier of World War II. The M1 remained a common and popular rifle for civilians after the war. In 1963, almost 250,000 M1s, capable of holding between 15 and 30 rounds, were sold at steeply discounted prices to law-abiding citizens by the federal government. The ultimate successor to the M1 was the M16, with a civilian version dubbed the Armalite Model 15 or AR-15. The AR-15 entered the civilian market in 1963 with a standard 20-round magazine and remains today the most popular rifle in American history. The AR-15 was central to a 1994 Supreme Court case in which the court noted the semi-automatic rifle, capable of firing only one shot with each pull of the trigger, traditionally have been widely accepted as lawful possessions. By the early 1970s, the AR-15 had competition from other American rifle models, each sold with manufacturer's standard 20-round or greater magazines. By 1980, comparable European models with similar capacities entered the American market. The point of our long march through the history of firearms is this. The record shows that firearms capable of holding more than 10 rounds of ammunition have been available in the United States for well over 2 centuries. While the Supreme Court has ruled that arms need not have been common during the founding era to receive protection under the Second Amendment, the historical prevalence of firearms capable of holding more than 10 bullets underscores the heritage of LCMs in our country's history. Thus, we hold that LCMs are not unusual arms, and because LCMs are not unusual, we need not opine on their dangerousness under the court's test. While the political branches enjoy latitude to craft legislation to stamp out gun violence, their powers are not limitless if they encroach on an enumerated right enshrined in our Constitution. Moreover, the Second Amendment is more than just a right guaranteed in our Bill of Rights. As the Supreme Court has held, self-defense is a fundamental individual right that is necessary to our system of ordered liberty. It is also pre-existing. This is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. In short, the right of armed self-defense sits atop our constitutional order and remains rooted in our country's history. Any law that limits this right of self-defense must be evaluated under this constitutional and historical backdrop. The seeds of the modern right to defend oneself germinated from fertile ground long ago. The English Bill of Rights, considered the predecessor to our own, conferred an individual right to self-defense. Quote, "The right secured in 1689 as a result of the Stuarts' abuses was, by the time of the founding, understood to be an individual right, protecting against both public and private violence. And by the time of the founding, the right to have arms had become fundamental for English subjects. American colonists similarly understood their rights to include the right of self-preservation as permitting a citizen to repel force by force when the intervention of society in his behalf may be too late to prevent an injury. This belief was galvanized by George III's attempt to disarm the colonists just as the Stuarts attempted to disarm the Protestants. Before our federal Bill of Rights was ratified, at least 4 states, Pennsylvania, Vermont, North Carolina, and Massachusetts, included within their state constitutions or Declaration of Rights a guarantee to keep and bear arms. Shortly after the ratification of our Constitution, at least 9 states' constitutions enshrined a right of citizens to bear arms in defense of themselves and the state, or bear arms in defense of himself and the state. Perhaps the most poignant and persuasive reminder of the fundamental right to self-defense rests in the denial of that right to Black Americans during the tragic chapters of our country's history. After the founding, Southern states often severely limited or outright prohibited firearm possession by slaves, freedmen, and others. The judicial branch, too, played a role in denying this fundamental right of self-defense to blacks. In the infamous Dred Scott v. Sanford decision, Chief Justice Taney recited a parade of horribles if Black Americans were to be considered citizens. It would give blacks the right to enter every other state whenever they pleased, to exercise full liberty of speech, to hold public meetings upon political affairs, and to keep and carry arms whenever they want. It did not get much better even after a bloody civil war that tore the country apart. Post-Civil War state legislation and the black codes in the South deprived newly freed slaves of their Second Amendment rights. Meanwhile, armed bands of ex-Confederates roamed the countryside, forcibly disarming and terrorizing African Americans. The radical Republicans in Congress fought back against these systematic efforts to disarm Black Americans by enacting the Freedmen's Bureau Act of 1866 and the Civil Rights Acts of 1866. Both of which guaranteed all persons the right of self-defense. But laws promising protection and equality for African Americans rang hollow because in the post-Reconstruction era, the Ku Klux Klan and other marauding bands of terrorists slaughtered thousands of unarmed Black Americans. Not surprisingly, Black Americans embraced their right to self-defense, understanding that protections offered by the state may be promising in theory, but fatal in fact. Ida B. Wells, the crusading journalist who co-founded the NAACP, wrote that a Winchester rifle should have a place of honor in every black home, and it should be used for that protection which the law refuses to give. Martin Luther King Jr., despite his nonviolent approach to protest, owned numerous firearms and hired armed men to guard his house during the Montgomery bus boycott in 1956. One civil rights activist who visited Dr. King's home during that time described the house as an arsenal. Stories of other civil rights activists exercising their right to self-defense are legion. While the NAACP espoused nonviolence, many of its members carried firearms for self-protection, and for good reason. Aaron Henry, then a branch president of the NAACP, would openly display his firearm after his house was firebombed in 1963. When NAACP activist Hartman Turnbow tried to register to vote, night riders lit his house on fire with Molotov cocktails. Turnbow recounted that he grabbed his rifle, escaped the burning building, and exchanged gunfire with 2 white men waiting outside. The men fled once Turnbow started shooting back. Wells documented that, of the many inhuman outrages of that year, the only case where the proposed lynching did not occur was where the men armed themselves and prevented it. The only times an Afro-American who was assaulted and got away has been when he had a gun and used it in self-defense. During the crucible of the civil rights movement, Black American veterans from World War II and the Korean War founded the Deacons for Defense and Justice to protect black people from racial violence at the hands of the Ku Klux Klan. In 1966, the small Louisiana town of Bogalusa integrated the local junior high school to the ire of the local Klan. Armed with guns, this roving band of racist terrorists arrived at the junior high school. Their intentions were obvious. In that small town, 2 African Americans, one of whom was a deputy sheriff, had recently been killed by white people. But this time around, the Klan encountered something unexpected at the entrance of the school. The Deacons for Defense and Justice, armed with revolvers and rifles, and rooted in righteousness and resolution. Outgunned by the Deacons, the Klan fled. As one member of the Deacons noted afterwards, from that day forward, we didn't have too many more problems. These terrible events did not occur long ago in faraway lands. They occurred on American soil some less than 60 years ago, and tragically, they are not unique. Indeed, Black Americans' existence throughout the civil rights movement was just the latest iteration in an ongoing struggle to defend hearth and home from those who wished them ill. This was part of a long-standing tradition of revolts, armed resistance, and self-defense that developed during slavery and continued after emancipation when Reconstruction failed to deliver political and social equality for Black Americans. Our country's history has shown that communities of color have a particularly compelling interest in exercising their Second Amendment rights. The Second Amendment provides one last line of defense for people of color when the state cannot or will not step in to protect them. This remains true today across all communities of color. For example, amid the COVID-19 pandemic, Asian Americans have become the target of physical attacks by those who scapegoat them for the virus. In response to those assaults and threats to their lives, Asian Americans have begun arming themselves. When one Asian mother was asked why she was buying a pistol, she replied in tears, "To protect my daughter." Another Asian immigrant purchasing an AR-15 rifle feared violence should COVID-19 deaths continue to mount. Quote, "And when all these bad things come, I am a minority. People can see my face is Chinese clearly. My son, when he goes out, they will know his parents are Chinese." People of color are not alone in relying on the Second Amendment to protect themselves when the state's protections fail them. We need look no further than the facts in the Supreme Court's Caetano decision. Jaime Caetano obtained multiple restraining orders against her abusive boyfriend after he put her in the hospital. Unfortunately, restraining orders meant little to her abuser. He continued to stalk and menace her. One day, he waited for her outside her workplace, but this time she came armed. The abusive boyfriend got scared and left her alone. Her story is not unique. For many women, a firearm may be the equalizer against their abusers and assailants when the state fails to protect them. So too, for members of the lesbian, gay, bisexual, and transgender communities. They are disproportionately the victim of hate crimes and other types of criminal violence because they are perceived as safe targets for violence and hateful acts. As Amiki Pink Pistols explained in their brief, armed self-defense can dispel those perceptions and deter such attacks against LGBT members. We mention these examples to drive home the point that the Second Amendment is not a second-class right. Nor is self-defense a dispensation granted at the state's mercy. Rather, the Second Amendment is a fundamental constitutional right guaranteed to the people, especially those who may not be equally protected by the state. Moreover, the Second Amendment is not a relic relevant only during the era of Publius and parchments. It is a right that is exercised hundreds of times on any given day. The parties and amici disagree on the number of times that guns are used for defensive purposes, offering anywhere from 240,000 to 2.5 million times per year. That means an average of 657 Americans, and perhaps up to almost 7,000 Americans, use guns to defend themselves every single day of the year. We take notice of this fact in recognizing the fundamental right of self-defense. In any event, it does not take a wild imagination to conclude that citizens may need LCMs to defend hearth and home. While Hollywood and the Bay Area symbolize California to the world, the Golden State is in fact a much more diverse and vibrant place, with people living in sparsely populated rural counties, seemingly deserted desert towns, and majestic mountain villages. In such places, the closest law enforcement may be far, far away, and it may take substantial time for the county sheriff to respond. And it is no guarantee that the things that go bump in the night come alone. Indeed, burglars often ply their trade in groups, recognizing strength in numbers. Law-abiding citizens in these places may find security in a gun that comes standard with an LCM. Further, some people, especially in communities of color, do not trust law enforcement and are less likely, over 40% less likely according to one study, to call 911 even during an emergency. These citizens may rely more on self-defense than the average person in a home invasion or some other emergency. I mean, I personally have a major concern with calling 911 in the States because I don't know, half the time the police respond, they've already got some idea of what they think happened without even talking to the parties, and they're already acting against someone's best interests, or the best interests of the situation. The big one that I keep hearing is when someone calls police to respond to a mental health situation, the police end up shooting and killing the mentally ill person who really just needed a mental health intervention as opposed to a violent intervention. Law-abiding citizens trapped in high-crime areas where law enforcement is overtaxed may defend themselves in their homes with a handgun outfitted with LCMs, and in incidents of mass chaos and unrest, law enforcement simply may be unable to protect people, leaving them solely responsible for their own safety in a seemingly Hobbesian world. Finally, many citizens will not take any chances or compromise their ability to defend themselves and their families, and they may place their trust in guns equipped with LCMs as a last resort. Simply put, the guardrails found in our precedent that limit the government's intrusion on the Second Amendment right do not exist in California's near-categorical ban of LCMs. It imposes a substantial burden on people's Second Amendment rights. Strict scrutiny applies. Let us be clear. We are keenly aware of the perils of gun violence. The heartbreak and devastation caused by criminals wielding guns cannot be overstated, and we also understand the importance of allowing state governments the ability to fashion solutions to curb gun violence. We have thus held that California can, for example, impose waiting periods, require micro-stamping of guns, and forbid felons, the mentally ill, or misdemeanants convicted of domestic violence from owning firearms. We also want to make clear that our decision today does not address issues not before us. We do not opine on bans of so-called assault weapons, nor do we speculate about the legitimacy of bans on firearms holding far larger quantities of ammunition. Instead, we only address California's ban on LCMs as it appears before us. We understand the purpose in passing this law, but even the laudable goal of reducing gun violence must comply with the Constitution. California's near-categorical ban of LCMs infringes on the fundamental right to self-defense. It criminalizes the possession of half of all magazines in America today. It makes unlawful magazines that are commonly used in handguns by law-abiding citizens for self-defense, and it substantially burdens the core right of self-defense guaranteed to the people under the Second Amendment. It cannot stand. We affirm the district court's grant of summary judgment for plaintiff appellees. The dissenting opinion basically disagrees that intermediate scrutiny should apply and that intermediate scrutiny should keep the ban, should affirm the ban. And so that's basically the difference without going into the details. The one dissenting judge basically felt that the 10-round magazine ban was more reasonable and it fell under intermediate scrutiny, and under intermediate scrutiny, the ban was allowed. So obviously the two judges on the panel agreed that it was unconstitutional, and so the ban is overturned. And I think for now, that's the end of it. You can now possess magazines that are greater than 10 rounds in California under whatever other California laws are. I don't know if there's a waiting period or an import ban or a sales ban or whatever, but all those people who hadn't turned in or hadn't thrown out or hadn't destroyed their magazines, or maybe they altered their magazines, well, they can alter them back now, in my opinion. Again, I'm not an expert attorney. This is not legal advice. You're going to want to figure out for yourself whether there's some other California law that applies. But according to this, you can now possess magazines with greater than 10 rounds in California. So let me know what you think of that. Do you think that the court was right in its analysis? Do you think that the statistics they cited, that 10-round plus magazines or 11-round plus magazines are really not the thing that causes mass casualties, that it's something else, it's bringing multiple weapons or smuggling high-capacity magazines or something? What do you think of the judge's thoughts on that? And you know, how do you feel about the opinion? If you are happy that the opinion makes the ban unconstitutional, are you going to enjoy the fact that you don't have to turn over your magazines, you don't have to buy new magazines or buy kits to change your magazines? I personally, you know, aside from my carry weapon, everything I use has a large capacity magazine in it. For competition, everything's going to be basically the largest capacity magazine allowed by 3-gun competition in my case. So I'm more or less happy to see this ruling. I wasn't really thinking that Pennsylvania was going to impose such a restriction, but I'm glad to see that the people of California, who are law-abiding gun owners, can now have their large capacity magazines. Let me know what you think in the comments below. That is our show today. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, Floatplane, and Twitch. This is a community-supported channel, meaning we need your monthly financial support on patreon.com/ljfrench and sponsors.com/law. Thank you in the month of August to the following $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Benjamin Hitov, Steven, Blackleaf, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, engi, Brandyn, Abel, Torpedan, and Creative Corruptions. And thank you to the $5 plus supporters who are scrolling on the screen in front of me and will be in the description below. The LED panel app was not working, so we did not get to use that today. I love you all. I will see you in the videos that drop. Have a great week. Bye.